There was a movie where I think someone said, I need a bigger boat. I think I need a bigger courtroom.
I'll put that request in for you.
What's that?
I'll put that request in for you.
For a bigger courtroom? There's only one that's bigger,
I know.
and that's the Chiefs. Okay, I want to see that. Let me just ask both sides. I think that some people were excluded from the courtroom because every seat in the courtroom is taken. So I just want to make sure that there isn't anybody that either side wanted, needed in the courtroom that we need to address, and I don't know if we have to throw somebody out to get them in, but I also at the same time want to make sure there isn't somebody in the courtroom who shouldn't be in the courtroom. I don't know that the rule has been invoked.
It will be as of right now, Judge.
All right, so the rule has now been invoked. So if there's anybody who is in the courtroom who is a witness in this case, you cannot remain in the courtroom. I'll rely on both sides to scan the crowd and see if you see anybody who is one of your witnesses. It does not look like anybody is volunteering that they are a witness.
None of the defense witnesses are in the courtroom.
Neither are the state witnesses.
All right, excellent. I will then ask you to relay the invocation of the rule and its requirements to your witnesses. State, I know that you have some witnesses outside that are ready to testify as soon as closing arguments are completed. I will ask you to call your first witness and we'll begin the testimony.
We're checking now, Judge.
All right. Go ahead. I'll give you a few moments.
You're going to wait. She can go check over.
All right. Bob's probably settling them. I mean, so it's going to take a minute. He had to walk him around the back and put him in the room. But other than that, is the state ready?
Yes, we are.
Is the defense ready?
Yes, Your Honor.
Ms. Holt, will you be giving the opening for the defense?
Yes, Your Honor.
And for the state, who's giving the opening?
I'll be giving you.
Mr. Terry? All right. And we already went over 2.1 and 2.1a. I have it in front of me. When we bring them in, I'll welcome them back. I will tell them that they're going to get the first of the instructions. I'll read them 2.1, 2.1a, and then I'll allow the state to begin with the opening statement and the defense to follow. Deputy Oliver, can you radio Deputy Board just to make sure he knows that we're ready for the jury? He might have thought that it was going to take us longer. I'll let the record reflect that everyone is present, including the defendant, Ms. Nachtman. State still ready?
Yes, sir.
Defense still ready?
Yes, Your Honor.
All right. Jury is present and seated. Everyone else may be seated this time. Ladies and gentlemen of the jury, welcome back. Good afternoon. First and foremost, I want to confirm, because I always tell people in my panel that they sit out there in those hard benches, that the seats here in the jury box are much more comfortable. Can I confirm that you are more comfortable there?
Yes.
All right. Well, that's good, because that's where you will be for the next 2 weeks for this trial. You also will come and go from this door, and the bailiffs will have some additional instructions for you about how we start court in the morning and all those types of things, where to meet them. As I indicated during jury selection, the court would have instructions for you throughout the course of the trial. The first instructions that I have for you this afternoon are titled preliminary instructions. They're not very long, but I am going to read them to you. They are written by the Florida Supreme Court, and every word of them is important. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Nicole Nachtman. This is a criminal case. Nicole Nachtman is charged with 2 counts of murder in the first degree, premeditated, with a firearm. The definition of murder in the first degree, premeditated with a firearm, will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Nicole Nachtman in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and will deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family member make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences do occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. That is all of the preliminary instructions. Let me just verify with you, we recycle our pens, so they run out of ink eventually. I want everyone to take their pen out and take it for a test drive and let us know if you need a new pen because yours is not working. I also, at this time, want to let you know that if any time during the course of the trial your pen runs out of ink, do not be shy. Raise your hand, get my attention, or Deputy DeVore's attention, or any other bailiff who's sitting close to you, and they have a supply of pens and will be able to get you a new pen.